The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to explain the difference between revocable trusts and irrevocable trusts. We'll explain how trusts work and what it means to be revocable versus irrevocable, and then we'll talk about what each type of trust is used for. So first, let's talk about how trusts work. Trusts are both a legal document and an entity that can own property. So when you create a trust, you usually transfer some assets into it, and the trust document doesn't list what assets it owns, but it lists how those assets are going to be treated, who they're going to be distributed to, when, how they're going to be invested. So when someone creates a trust, that person is called the grantor, and the grantor usually transfers assets into the trust and will name a trustee to be responsible for managing those assets for the benefit of the beneficiaries, according to the terms of the trust. And the grantor, usually with revocable living trusts, will be often the same person as the trustee and the beneficiary while they're alive, and then that they'll name successors to take over as trustee for different people, maybe their kids, as beneficiaries once they pass away. In an irrevocable trust, usually the trustee and beneficiaries might be different people from the person creating the trust, the grantor. So let's talk about the difference between a revocable living trust and an irrevocable trust. For a revocable trust, the grantor maintains control, really, over the assets that are transferred to the trust during his or her lifetime. The grantor has the opportunity to modify the trust at any time, basically take all the assets out of the trust and revoke the trust if he or she desires. So the trust only kicks in and kind of becomes irrevocable at the point that the grantor either becomes mentally incompetent or passes away. An irrevocable trust, immediately once assets are transferred into it, the grantor gives up some control over those assets. And the grantor doesn't retain the right to unwind the trust unilaterally or change the terms of the trust unilaterally. Even if the grantor tells the trustee, hey, I want my assets back, the trustee has a duty to serve as trustee according to the terms of the trust for the benefit of whoever the beneficiaries are. So revocable trusts and irrevocable trusts are used for very different purposes. When someone transfers assets into a revocable trust, those assets are treated for many intents and purposes like the transferor's individual assets. So for tax purposes, the purpose of creditors trying to get at your assets, if you own assets and you're the grantor of a revocable living trust and the assets are owned to the trust, for many purposes those will be treated as your assets during your lifetime. Assets owned by an irrevocable trust are not generally treated as the grantor's assets. So for this reason, you can do things like creditor protection with irrevocable trusts and some other things that we're going to talk about in a moment. Let's first talk about what we use revocable living trusts for. A revocable living trust is often a basic estate planning document. When most people come to us and say, I need a will, what they really could use is a revocable living trust. A revocable living trust does most of the things that a will can do. It can name who you want to be responsible for managing your estate and how you want your assets distributed, but it has the added benefit of avoiding probate. Probate is a court case that takes about a year. That's usually required if you don't have a trust. It's required if you have any real estate outside of a trust or outside of joint right of survivorship with your spouse usually, or if you own $100,000 or more in non-real estate assets outside of a trust or outside of payable on death accounts. So for most people, probate is required if you don't have a trust, and probate is something we want to avoid because you have to hire an attorney. The attorney is going to cost a fair amount of money that's going to be taken out of your estate and not get to your beneficiaries. It takes about a year before your assets are distributed, and it's stressful for your family. So the way we avoid probate is we draft a revocable living trust that lays out how you want your assets distributed or maybe managed for years after your death for the benefit of minor beneficiaries. And we transfer your major assets like your house, any major savings accounts into the trust. And if we do that right, any assets that aren't owned by the trust are going to get swept into the trust when you pass away, and probate's not going to be necessary, and your trustee can immediately manage those assets for the benefit of the beneficiaries, often without hiring an attorney. So that's what we use revocable trusts for, mainly probate avoidance. The second thing we use revocable trusts for is basically allowing married couples to take advantage of one another's estate tax exemption. Your estate tax exemption is the amount of property you can own when you pass away without being subject to estate tax. In Illinois, it's $4 million, which is pretty good, but life insurance death benefit is included in that. So pretty quickly, when you add up all of your assets and life insurance death benefit, you can get to $4 million without really feeling like you're super wealthy. Each individual has a $4 million exemption, but we can, through a use of an A-B trust strategy, it's called, allow couples to take advantage of each other's exemption and raise that essentially to $8 million for the couple rather than $4 million for each of them as an individual. And this is usually our first line of defense in estate tax planning, is raising that exemption from $4 million to $8 million for the couple through the use of revocable living trust. So if in this case, instead of using one trust for the couple, a joint trust, we would use one trust for each, and now they're avoiding probate and raising their estate tax exemption. Irrevocable trusts are used for three things mostly. One is end-of-life long-term care planning. Another is creditor protection. And a third is more advanced estate tax planning. So let's talk about end-of-life long-term care planning first. So long-term care can suck up the assets of an estate pretty quickly. Everyone knows how expensive it is. You can get onto Medicaid to pay for your long-term care, but first you have to spend all of your assets and sell your house and basically eliminate any inheritance for your children. One thing we can do with an irrevocable trust is divide up the ownership interest in, say, the family home, so that doesn't have to be spent down for Medicaid purposes. And the way this works is you put the family home into an irrevocable trust, you transfer ownership to the irrevocable trust, and the grantor, the person who is going to need the long-term care, maintains a life estate. This means that they get to live in the house for the rest of their life, but they can't sell it. And their kids are future beneficiaries of this, and they have a present interest to inherit the property. What this means, it's different from a revocable living trust because it can't be changed. Once you transfer it into the irrevocable trust, the children have an immediate right to inherit the property, meaning you can't sell the property without the children's consent. So if you do this 5 years or more before needing long-term care, then you can put assets into these trusts, retain some right to use the assets during your lifetime, and allow your children to inherit the assets without having to spend them down before getting Medicaid benefits. The trick is you have to do it 5 years prior to actually needing those Medicaid benefits. Otherwise, the strategy doesn't work. We've got a lot more on long-term care planning at learn-about-law.com, so I won't go into a ton of detail here. The next thing we use irrevocable trust for is creditor protection, and we do the same thing. So say the family home, you have the grantor of the trust retain a right to possess the home during their lifetime, and then their children may have a present right to inherit once that grantor passes away. So this means you've divided up the ownership interest by putting it into an irrevocable trust, and creditors that you owe a debt to can't go after the family home and force you to sell it. They can't, or any other assets in the trust. They can't go after the principal balance of the trust. What they can do is do something called the charging order, which requires you to pay any income earned off of assets in the trust to the creditors before taking it yourself, but it protects the balance of the principal of the trust, principal assets for the next generation against creditors' claims. Finally, we use irrevocable trust for more advanced estate tax planning scenarios. So a couple examples here. We've already raised through a revocable trust your estate tax exemption from $4 million to $8 million. So now we're talking about you've got more assets than $8 million, and we need to figure out ways to remove them from your estate. The revocable trust strategy doesn't remove anything from your estate. It just raises your exemption. With irrevocable trust, we can remove assets from your taxable estate. The first line of defense is something called an ILIT, Irrevocable Life Insurance Trust. And this basically allows you to put a life insurance policy and have it be owned by an irrevocable trust. You can't change the policy, but the death benefit is no longer part of your estate. So that $1 million death benefit no longer counts as one of your assets when you pass away for estate tax purposes. The next line of defense are things called grits, grats, and groots. And what these are, they're grantor retained income trust, grantor retained annuity trust, and grantor retained unit trust. Basically, you're able to transfer real estate or a business asset into one of these trusts, and the value of the asset on the day you transfer it is the value that is considered part of your taxable estate, but any increase in value of the asset over the course of, say, the next 20 or 30 years is not part of your estate, and that can go to the beneficiaries immediately. So we have, again, a lot of estate tax planning articles. I'm not going to try to dive into it here, but the main thing we use irrevocable trust for estate tax purposes is giving up some lifetime control over the asset while retaining some lifetime control over the asset and removing that asset from your estate. So what estate tax planning often is trying to minimize what's actually part of your estate, and we do this with irrevocable trusts that are closely tailored to your particular needs. So to review, revocable trusts, you retain control over everything during your lifetime. Irrevocable trusts, you're giving up some control while usually retaining some control. Like the life estate in the house, you retain the right to possess it, but you can't sell it. Irrevocable trusts we use to remove assets from your estate for long-term care purposes or for estate tax purposes, and to shield assets from creditors in order to make sure your assets get to the next generation or to your loved ones of any generation. So if you have any questions, you can leave them in the comments section below this post at learn-about-law.com or below the video on our YouTube page. If you found this helpful, please subscribe to us on YouTube, SoundCloud, and Apple Music. We just lost iTunes a couple weeks ago. So if you need some help, you can give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations, and we have offices all around Chicagoland for your convenience. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.